Hello, everybody. Okay, so I'm going to give some immigration attorney updates on stuff that's been happening. And, if you have any questions, just pop them in there. So, as many of you have heard, the regulations, the executive order of Biden's ability and way to help those who have been here for many years is going to be coming out shortly. Okay, so I wanted to give just a little, tidbit essentially on what it is that he said, so that at least you have some idea. Because I'm getting a lot of, people who think whatever their situation is, they're going to be able to qualify for this Biden executive order, and they're going to be able to get their green card, whereas before there was nothing they can do. So let's start with the basics. First of all, if you're married to a U.S. citizen or lawful permanent resident, then in that particular case, you may qualify for this. Now, the way, first of all, to see if you qualify is to determine if in fact you have any way to adjust status without the help. Okay. Obviously, if you entered the country legally but just fell out of status, then you would be able to just file a normal adjustment, go through the exceptions. So the idea here is that if you entered the country illegally, you have a lot of unlawful presence, at least more than a year, and you've married a U.S. citizen, or you've married a lawful permanent resident that will become a U.S. citizen, then this could very easily apply to you. There's a lot of people who right now they have the ability to do what is called, first they do the consulate processing, and then they do the provisional waiver. And the provisional waiver is when they leave the United States, and hopefully they have a provisional waiver at the time. They go to the consulate, and if everything goes smoothly, they come back as a lawful permanent resident. But I have found a lot of times that people just don't want to do that. They don't want to take the risk of leaving. So now there is the opportunity with the Biden executive order to be able to not have to do that, to not have to leave, and to do what they call, the parole in place application is sort of a fiction. It's a legal fiction. They file when the regulations come, they will file the application for a parole in place. That gives the legal fiction that they entered legally. Okay. And then once that would hopefully be approved, they wouldn't need the provisional waiver of inadmissibility. They wouldn't need to leave the country. And then they would have a parole in place approval, so they'd be able to apply for adjustment of status. Okay. And that's how it works. It will make it so that somebody who is married to a U.S. citizen or to a lawful permanent resident will be able to adjust status in the U.S. without having the fear of leaving, without having to wait for, it's literally taking now 2 to 3 years for a provisional waiver to be adjudicated. I mean, I'll be honest with you, they probably spent 15 minutes on it, but the backlog is so great that that's how long it's taking. So right now, if you have a provisional waiver or the ability to do a provisional waiver and leave the U.S. ultimately to eventually come back, then you might want to wait for these regulations. The word is that the regulations on the executive order will be issued sometime at the end of August. Now, normally, when a president issues executive orders of this nature, the other side of the aisle will, sue up and down to say, you don't have the authority to do this and so forth. And that might still happen. Who knows? It may come. But as of right now, there's nothing in the pipe works. Maybe they are also waiting for the regulations to come out. But this will be very helpful to those people. So I do have a lot of people who want to do the Biden executive order. And what they do is they have criminal histories. Okay. They want to know, do we qualify to go under these Biden executive orders, even though they might have a criminal history? They might be inadmissible based upon some different kind of event. So, inadmissibility in immigration law, there's a book on it, okay? I mean, there's a lot of grounds of inadmissibility, fraud, misrepresentation, criminal history, medical, if you don't make enough and so forth, or the petitioner doesn't. So what I was talking about in the first place is a real clean issue of someone who's inadmissible only under unlawful presence, someone who's married to a U.S. citizen or lawful permanent resident, and someone who entered the country illegally. Okay, and we can add one to it, someone who doesn't have a deportation order. And so the idea is that that's the real clean version of it. Now, the fact is that 70 to 80% of the people who want to apply for this will not fall under the real clean version and will want to know if they qualify. Well, a lot of things in law, especially immigration law, fall within the gray area. And that's where, it's not specifically defined whether or not they might qualify, or it's, wishy-washy, that's not a legal term, but whether or not they care, okay, whether or not they can argue that they still fall under the regulations. So naturally, we need to see what the actual regulations will say, what the actual regulations will do in order to see if it argues. But for example, it might say, if you have, and this was in the words, if you have a non-serious crime, then you can still apply for this. So obviously that's a gray area. What do you consider a non-serious crime? Well, obviously the immigration attorney would take the case and would argue up and down and all kinds of reasons why whatever it is, doesn't have a non-serious crime. So given that, you'll still be able to qualify and still be able to argue and still be able to submit the application. So nobody can say to you 100%, well, 100% you will qualify and no problems. It doesn't work like that. So, if it's a matter of doing the provisional waiver, leaving and having to maybe come back versus trying this and seeing if it works, well, I would say try it, okay? Have someone who knows what they're doing file it, okay? So let me look at here. It says, there's a question here. My husband has his individual hearing, then it was changed to master calendar. Why does that happen? Okay. Well, the individual hearing is essentially the trial, okay? And the question is, what has happened before this point? So was it transferred to another judge? Was there a motion made that changed things? Was a crime vacated? The reason it would, or was there a motion for change of venue? Things like that. So something had to change in order to switch it to a master calendar. Otherwise, it wouldn't have switched. So first thing I would do, if you really have no idea, the first thing I would do is look and see if the judge is the same. There are judges that retire, and then what happens is their caseload gets dispersed among all the other judges, and there's no way a new judge is going to just take a case as an individual on an individual calendar without knowing what's going on, without being updated, and without seeing if there's anything else that can be done. So in regards to that, that's what you have to look at. Something has changed. Okay, it's not necessarily negative that this has happened. There could also have been a change in law. I don't know what kind of case he has, if it, nothing is surefire, 100%. So I don't know how strong his case might have been, but if there's any doubt as to the strength of his case, the fact it's moved to a master calendar is a good thing. If he was ready to rock and roll and go forward and had a really good case, well, then it might be more of an issue. But that's the gist of what has happened. Can an ICE hold be uplifted? Okay, so the answer to that is not real likely. Okay, that's not the question you should be asking. You shouldn't be asking if an ICE hold can be uplifted, which I think you're saying can an ICE hold be removed. What you should be saying is, how can you win an immigration hearing even though there's an ICE hold? Okay, the people in ICE, they don't care. They don't give one hoot about the person they put the ICE hold on. As far as they're concerned, they have someone who committed a crime, they're putting the ICE hold, and they're going to send that person to removal proceedings. And the first thing they're going to try to do is they are going to try to get that person to sign a document saying, please deport me, I don't want to fight my case. And they're going to do everything they can to try to make that happen. Okay? That's the reality. And a lot of times, the ICE officials will lie. They'll say, well, you don't have a case. You are going to be in detention for 22 years. There's no way you can appeal it, blah, blah, blah. And they'll say things like that. And they'll get the person scared. They'll say, all you have to do is sign here and everything will be hunky-dory. Okay, and in fact, what they're doing is they're signing there. And by signing there, they're basically saying, I'm not going to fight my case. I don't care what you do to me. And what happens is they're still going to get transferred to immigration detention. And depending where they happen to be from, they're going to be waiting maybe for a month for a plane to be, retrieved so that they can be formally deported. And in that whole time, they could have been fighting their case. So do not sign the please deport me letter. Okay? So another thing you don't want to do is talk to the ICE official any more than you have to. You're not required. You're not required to sign. You're not required to give information. You can just be nice and say, I'm sorry, my immigration attorney told me I'm not supposed to disclose any information. I want to see the immigration judge, period. Just leave it like that, no matter what they say. Okay? You might not have a good case. You might lose. But the immigration ICE official doesn't know and doesn't care. Okay? You're just another person on their docket. So, never give up your right to fight, a case depending upon what it is that, you have. And there's a lot of times that you don't know what relief you might have available to you, okay? If you have relief available to you, you should see an immigration attorney to go forward to try to determine if something can be done, okay? All right, so here's a question. Can't Trump undo the exec order if he wins election? Absolutely. 100%. Okay, 100%. If he gets elected on the first minute of the first day that he's there, he can void that executive order. Okay, I mean, that's a fact. So that's why President Biden was trying to get congressional action on the, immigration situation, which he almost had until Trump decided to tell everybody not to do it so we could have better points. So executive actions can always be overturned by the next president. But the fact is that if the executive action gets into place and if you apply for it and if it goes through, then it's a whole different story whether they can revoke that application. Let's say if it's approved, that's you're good to go, okay? But let's say it's midstream. And let's say that Trump wins and let's say he revokes the executive order. If an application is midstream, then it's likely it cannot just simply be revoked and that one will still go forward. So that's the more of the reason why if these regulations come out and you could qualify, don't wait. Okay, get it in there right away so that even if it is ultimately revoked or ultimately, they fight it and, it turns out that some of it gets stricken down, at least you'll be in the pipeline and you'll have a whole lot better chance of things going through. Okay. Now, the other part of the executive order deals with DACA. Okay, so there's a lot of people who are have been here for the majority of their lives. They came here as little kids. They don't even remember how they came here. And they're on DACA now with no hope in sight for getting various, work permits or other things that they couldn't get. And so this new executive order essentially says if you have a college degree and you meet the qualifications and you get a job offer related to that, you're going to be able to get a work permit very easy. Okay, so that's a good thing. So that is essentially how the new statements, at least on the executive order, work. And the idea, hopefully, is that when the regulations come out, that they'll be, more very easy to understand and so forth. I mean, I'm a lawyer. I understand that what's going to happen is there'll be ambiguities up and down in it. And sometimes it even takes years for all the lawsuits to go through. But I also know that when these things come out, if you get your application right in the beginning, they may be more likely to get approved, even though they might not later, because it is right in the beginning. And the USCIS official who's adjudicating it, they're not experts on it either. And they go, well, okay, I guess this meets the qualifications. Before you know it, months later, USCIS is putting out a memo saying, well, okay, if A, B, C, D, E, or F happened, then you're not supposed to approve, or you're supposed to send a request for evidence. So that all will affect it. So that's all the more reason. I mean, I can't say it any clearer. Jump on the bandwagon if you qualify, or if you think you qualify, once the regulations come out, to get it before all the riffraff comes down and it becomes much more difficult. Okay, so as far as there's a follow-up question on this one where it was changed to a master calendar. I mean, if a motion was placed, again, there's multiple kinds of motions. Okay, there's a motion to remand, a motion to reopen, a motion to reconsider. There's a motion to all kinds of stuff. So if there was something wrong in the record, it depends what was wrong in the record. Did they get the fact of how he entered wrong? Did they get the fact of how long he stayed here incorrect? Okay. It could all have an effect on cancellation of removal or other things. Like, for example, cancellation of removal says you have to be here for 10 years. Okay. And let's say that they said he came in 9.5 years ago, but let's say that that's clearly wrong. Okay. And they correct it to 14.5. Or to 9.5 years. If that's the case, he would qualify for the cancellation. So rather than, I mean, honestly, I could look at the record and determine in 5 minutes why they did it, but I don't have it in front of me. I don't know if he's representing himself or if he has an attorney, but it would behoove you to make sure that he's represented by an attorney, because you have to understand that the immigration judge, the trial attorney, none of these people view your husband as their friend and really want to help him. They come there day in and day out. They have 1,000 cases on their docket. No matter what they do, there will always be a bunch of cases on their docket. They don't have to be nice. They don't have to market anything, because there are always people there. Okay, so get an attorney to represent him in removal proceedings if he doesn't already have one. Okay, so I gave this live to primarily give an update on the Biden regulations, the Biden executive order. I hope that I have cleared up some stuff. Let me just answer this one last question. It says, are you licensed in Virginia? Let me tell you how immigration law works. Okay, first of all, I have clients all over the United States. And how can that be if I'm licensed only in California? Okay, how can that be? Well, immigration law is federal law. It's not state law. And that means that under federal law, I can be licensed in one state and practice anywhere in the United States and have clients anywhere in the United States because it's federal law. Now, that doesn't mean that case law and how things are adjudicated under immigration law are the same in Virginia as they are in California. That's not true, but it does mean I know exactly where to look, how to determine what the case law is, and so forth. And it's better to get an expert in immigration law than someone who happens to just be local. So that happens to be immigration law. There's also, you can think of other kinds of federal law, EPA, IRS, all of those types of laws, and they also can practice federally anywhere in the U.S. Obviously, if you were going to ask me a family law question, that is pure state law, so no way that's going to happen, or a criminal law question, although that's a little more complicated because there are crossovers between state criminal law and federal immigration, okay? And I do deal with that, okay? So that's that. You've been waiting for an interview at Islamabad for 1 year, 7 months. Is that normal? I'd say, yeah, it's normal now, okay? It didn't used to be normal. It is taking a long time, but the question is, what are you waiting for an interview for? Are you trying to get a visitor visa? Do you have consulate processing where your spouse petitioned you and you're going to get residency? Are you looking for a waiver? It depends what the interview is for. So what you want to do is, if the wait is extraordinarily long, you have to do two things. You have to, number one, you have to do a formal status inquiry. And number two, if they keep blowing you off and saying, well, it's an administrative processing, you can always file a writ of mandate. And those are not easy. I mean, that's suing the Department of State. But they're very effective because the U.S. attorney does not want to get in front of the judge and say, well, you judge, I understand it's only going to take us less than 10 minutes for the interview, but sorry, we just haven't had the time to do it. We understand it's been 1 year and 7 months. They're never going to do that, okay, because they know it's baloney. So, but it takes a lot of work to prepare a writ of mandate and to sue. So that is always the possibility. Yeah, I think we're all praying for the people who were injured at the rally. I mean, like they said, the number one most important thing for us to do if we have political views is to vote. Okay, not to do violence, because then you become, you look at those countries that's how they do everything, is through violence, and we don't want to be like that. So the hope is that once the voting comes, it's peaceful and people will take their number one democratic opportunity to vote and to get who they want in office. Okay, so let me just answer this question here. If a green card holder is trying to separate from a U.S. citizen spouse, does it delay the process? Well, it depends on what process you're talking about. I assume the question means that your husband or wife, whatever, has petitioned you for lawful permanent residency, and now you want to separate, and you're wondering if that petition will be delayed, and the answer is absolutely yes. Okay, you have to understand at the time of the interview, they're going to want both of you to be at the interview. Okay, they're not going to want just one, because they believe everybody that walks in the door is lying. Okay, that's what they believe. So they have to interview both of you to determine the bona fides of the marriage and so forth. So if you're separating, it absolutely positively will delay it, and it could likely end up getting it denied. So the question you have to ask is, do you stay with someone who's causing a lot of problems just to get the green card? And the answer is no. If your spouse has abused you mentally or physically, you can qualify for a VAWA application. Okay, that is Violence Against Women Act, but it can also, I've done VAWA for men as well. And you can move out tomorrow if you want. There is zero need to stay in an abusive relationship where you can find other forms of relief. And now you've answered. So it doesn't, the green card holder is trying to apply for citizenship. Again, that also depends. If the person applying for citizenship is applying under the 3-year rule, okay, so you're a U.S. citizen, obviously. So if they're applying under the 3-year rule, marriage to they got the green card because of marriage, then yes, it will absolutely positively get that denied, because you have to be in marital union living together for that to work. So all that means is if you're going to separate, the person trying to apply will have to wait until the 5 years is up and not apply under the 3-year marriage provision, but the 5-year normal, and then it doesn't make any difference. Okay. And what is the fee for the B1? Well, the fee for a non-immigrant visa is the same, okay, as any type of non-immigrant visa. Okay, you just have to send that to the consulate. It's like $265. I can never remember the exact amount. Okay, well, this will conclude the live for today. If you have specific questions, just send it to me. I'm a little behind. I get a lot of questions, but just send it to me and I'll be happy. I try to go on live once a week to answer the questions right here and there, so it's quicker. Okay. Anyways, all of you have a good day and enjoy the rest of your week. Okay. I always forget how to exit here. Just a minute. Okay. Well, it looks like I'm still on. End live. Okay.